Now, Patrick, this week you've been in London at the Julian Assange hearing.
That's right. This week was the U.S. extradition hearing for WikiLeaks founder Julian Assange, and as a lot of people know, he's being held in Her Majesty's Prison in Belmarsh, southeast London, and he's been awaiting extradition to the U.S. So we're going through the hearing process now. His legal defense team is obviously mounting a major challenge to U.S. extradition. So this was held, interesting, it was moved from the Westminster Magistrates Court, where it was originally intended to be, and moved to the secure court, which is affixed to Belmarsh Prison. This is for violent criminals mainly, and it's also a counterterrorism court, so it has all the features of the sort of secure facility, including a bulletproof glass around the dock, which sits in the back of the court, where the defendant will normally sit with the security guard. Moving forward here, this is Monday at 5 a.m. at the gates of Belmarsh Prison, so we had to queue up early every morning, Monday to Thursday, to sort of make sure you had a place. It's a very small facility, and a lot of media showed a lot of interest, Mike, the first 2 days, but less and less interest
as the time went on.
Yeah, it seemed to me like a lot of the media cut and ran after the prosecution gave their argument Monday morning, because they heard everything they needed to hear,
yeah, right.
And they moved on. But there was a pretty significant protest camp outside of the Belmarsh that seemed to get along very well with the prison administrators and the police and so forth. So it was peaceful. They were quite noisy as well, quite vocal, and that could be heard inside the courtroom, right, throughout most of the proceedings. So it did have an impact one way or another on the proceedings. But the support was it was international. People came from all over the world. Actually, I met there were hundreds of people that participated in this throughout, and that's not an easy location to get to out in southeast London.
Yes.
So just moving on here. So let's look at Julian Assange's extradition hearing. Let's look at what the defense is basically outlining in terms of their arguments here. And I mean, there's a lot more detail to this, Mike, and we'll point to various reports that you can find online, but essentially they're going for a challenge on the basis of abusive processes, and there's a number of things that the Assange's defense team believe that have been an abusive process by all authorities that have been involved in his apprehension, but also in the U.S., mainly in the U.S. government's 18 and 17 superseding indictments against Julian Assange. These include ulterior motives. They were saying these are political indictments, and a blatant misrepresenting of facts in the indictments themselves, which constitutes abusive process. So they challenged every single point that the prosecution made, and all of including the 18 indictments, and showed how flimsy this case was. In fact, how ridiculous this case was, and even debunked it, Mike, and dismantled it based on publicly available information that's already out there in public. It was absolutely shocking how poor the United States indictments are, and the fact that they say something on paper that you can actually refute in 1 minute on Google.
Reminds you of Russiagate, really?
It does. So it is beyond a joke, and so his defense is arguing there's no way we can possibly. They've been absolutely intentionally misrepresented the facts, and because the U.S. has all of this information, they argued. So there's no way that they could have got this wrong in the indictments. They've intentionally manipulated the charges to suit, to give them the ability to pursue the agenda that they want to sort of render him to the United States on a false pretense. So no extradition for political offense. This is a big one in terms of extradition law, and this is incredibly complicated because you're dealing with balancing between international treaties, human rights conventions like the European Human Rights Convention, and also bilateral treaties between the United States and the UK, and then also how this interacts with British law, with British Acts of Parliament. And so there's the question of what rights are being given, what rights are being mentioned, what rights are implied. It's incredibly complicated. There's a lot of room for interpretation here, and we'll show you some of these arguments. And also that he will not receive, this is the last point up here, he will not receive a fair trial in the U.S. And they made that argument pretty convincingly, just based on comments made by U.S. officials, comments made in the national media. Julian Assange is being characterized not as a journalist, but as some sort of cyber criminal and a Russian asset. And WikiLeaks is a foreign non-state actor, hostile intelligence service. So, based on all of these things, it's a pretty convincing case that he will not get a fair trial, or in the Eastern Court of Virginia, where it's a national security court and nobody has ever been found innocent in this court. So it's a complete kangaroo court. And by the way, the prosecutor, James Lewis QC, who, by the way, is working on the Bloody Sunday trial, is coming up as well. Obviously, all of the CVs of this level of lawyers are interesting to say the least. Yeah. But he made the comment straight off the bat in the first 5 minutes of his opening arguments on Monday morning that Julian Assange, quote, Julian Assange is not a journalist. So that was established by the prosecution from the beginning. And of course, that was very easily refuted by the defense. But let's move on and take a look at some other aspects of this. So we also have the violation of human rights. So including there the European Convention on Human Rights, Article 5, arbitrary detention. This has also been backed up by the United Nations. Article 10, which is kind of freedom of speech or freedom to publish information. So freedom of the press could be included under this as well, but also the Magna Carta as well. So the defense also mentioned the Magna Carta as an important protection for Julian Assange in this case. I mean, there's a number of other good details on this as well, which we didn't get to, but this was an article I published yesterday morning early, but Assange's courtroom drama speaks to this illusion of justice. And an incredible situation unfolded here. And what it was there were a number of complaints. Julian Assange complained early he couldn't focus, so possibly they needed to recess, but he also couldn't hear or couldn't hear what was being said.
Because he was inside this glass box?
He was inside a glass box at the back of the court. And that's very unusual for a nonviolent criminal who's not charged, not convicted with anything. But they're treating him like a terrorist, basically.
Well, no, they're not, because as we saw in the news this morning, the man that's accused of shooting the journalist in Londonderry dead has been released on bail, so they're not treating him like a terrorist at all. The terrorists get out on bail, Julian Assange doesn't. Yeah,
he's being held indefinitely in arbitrary detention. So what was interesting about this is the judge capitulated and gave him a set of headphones and a wireless receiver on Thursday morning, and he was wearing them for a while so he could hear what was being said about him. So, I mean, it doesn't look good, basically, from a, in terms of a fair hearing here in the 21st century. But he discarded them after a while and put them away, and he was, a bit reprimanded, or the judge said, well, we made this available to Mr. Assange, and so his lawyer said, we would like, they asked the judge, we would like our client to be released from the dock and to sit with us. And we'll show you, this is a courtroom sketch in the media. Here he is next to a Serco guard from the private corporation Serco. And one of the complaints they said was that, she said, well, you can go up and there's a slit in the glass and you can talk to your client through that slit in the glass. And they said, well, then the security guard can overhear it. Also, there's U.S. agents in the court. They could overhear as well. The prosecution can overhear. Number of people, so we don't have any private exchanges and communication between our client. So how can he engage and participate in his own hearing? And the answer is he can't. But she said, no, that's plenty. You have enough. You can pass notes. And she says, if we need to stop every 5 minutes, then you can go down in the basement, we'll recess, go down the basement, consult your client for 20 minutes, and come back. And they made the argument like, well, that's not very practical to run a trial like this. And she said, well, if it's scheduled for 3 weeks in May, witnesses and evidence from May 18th, but if it takes 6 weeks, so be it, said the judge. So it's impossible. Imagine stopping every 5 minutes just to speak to your client. She said, why can't he sit next to us? And they said, well, we have to bail him because he'll be out of custody. But they said, well, you can still be in custody and be in the well of the court. So it got into this technical argument. But So it was quite surreal, Mike, and just to see the absolute flat rebuffing of anything the defense was requesting in terms of being able to have access to their client, and he have access to the defense.
And what was the prosecution's attitude to this discussion?
The prosecution was very neutral. They supported either way. They had no objection at all to, it seemed, for Mr. Assange to be released from the dock. It was just a question of the how that would be done administratively, according to courts, the ways and means of the court, the Crown Court in this case. This is Woolwich Crown Court. This was being this hearing was being held in, Mike. But it's absolutely incredible scene because you could see there was they were not giving him any quarter whatsoever. So he was going to stay behind that glass box for the entire hearing coming up in May. That would be unbelievable, especially with some of the witnesses coming in, and especially because Assange himself is such a central figure in the story, and technically as well, has such a great technical knowledge and insight of all of the issues that are going to be discussed. So, but here's just a quick snapshot here. His two QCs, Edward Fitzgerald and Mark Summers, just sitting in front. He's behind them and quite far behind in the glass as well. Here is the judge, and when also confronted is Vanessa Bereza. She's the Crown Court judge in charge of this. And we don't have her photo up, Mike, because Craig Murray commented on his blog on this. She's the only person in Western Europe that doesn't have an image on the internet. One of the only people in known existence. Has zero footprint on the internet. So we've put this up here just to represent her. But she was confronted by the defense who said, and Julian Assange stood up as well and made outbursts to the court, shouting through the glass slits, Mike, saying that, and his defense said he had been strip searched twice between Monday and Tuesday, I think, and he was moved to 5 different cells, and he had his privileged court papers handcuffed 11 times, had his confidential attorney-client court papers confiscated by prison guards. So, and when challenged on this, Mike, this was the reply of the judge. I cannot be expected to rule on the conditions which Mr. Assange is being subject to. I'm paraphrasing slightly here from my notes, but you will have to take it up with Her Majesty's prisons.
Well, if she's not to be expected to rule on this, then who is?
Well, she's basically passing the buck to the prison system. But all of these things, especially having security at the prisons confiscate your legal documents, this has a direct effect on getting a fair trial. This could risk a mistrial. So it actually does. And in fact, there are precedents where the judge can rule on many of these things quite easily, in fact. So there's a lot of back and forth there, a lot of problems with these issues, Mike. So, but just moving on to the next issue is the issue of extradition, and this is incredibly complex. We'll just show you a couple of the main points of contention here. So there is a UK-US extradition treaty. It's been updated, but the original one was 1972, which bars extradition for political offenses. Here's the problem. It hasn't been incorporated completely into British law. So what you have is, and this is what the prosecution is arguing here, we have the UK's 2003 Extradition Act, which the political offense exception was removed from that act. So the act is effectively silent on the issue of barring extradition for someone for a political offense. And espionage, which is what the US are effectively indicting Julian Assange for, is by definition, really, it's a pure political offense. So the prosecution, James Lewis, is arguing, no, it's not in British law, so therefore it's not stated explicitly, so therefore it can't, we can't interpret international law in a British Crown Court.
Oh, really?
Yes, he's saying that it's irrelevant. So everything the defense is arguing is completely irrelevant, that we just have to execute this extradition order because we have an agreement with the US. So, but he is in effect trying to have his cake and eat it too. So this is a really complex issue, and it's really a British constitutional issue that he's invoking. He's invoking the sovereignty of Parliament there, and basically saying international law has no bearing whatsoever on how the court should rule on this. And then that gets into an argument. If it's not explicitly stated, Mike, it might be implied, and of course this is what the defense is arguing and showing a number of precedents where that actually happened. So this is a real battle here because this could make or break the case, this issue here. But let's look at what James Lewis, QC, he's the head of the U.S. prosecution team. So his basic argument is Assange is not entitled to derive any rights from the 1972 treaty, which is public international law, and no right to argue for political offense exception as it has been abrogated by Parliament in the 2003 Act. And there's reasons why they stripped it out. And there is, by the way, no extradition between European countries for political offenses.
Right.
David Shaler, they couldn't extradite him from France for that very reason. And if Catherine Gunn, for instance, the famous GCHQ whistleblower, if she had fled to France, they wouldn't have been able to extradite her back to Britain for breaching the Official Secrets Act. So this is an interesting point of argument here. Now here is the defense. This is Edward Fitzgerald, QC. He's head of Assange's defense team. This is what he's saying, or what they're saying. He called James Lewis's argument a very strange Alice in Wonderland world, invoking the sovereignty of Parliament, a bizarre argument. He went saying to rely on the treaty to file the application. The UK...
Yeah, so he's basically saying we have a treaty in place, so the extradition should go ahead, but we have to ignore the treaty when it comes to the political exemption.
The political exemption.
Yes.
So he's saying, in effect, that you can't have your cake and eat it too. So and if that was a very strong argument by the defense. So really, it's going to come down to which side this judge is going to side with, how the interpretation of that.
But based on what we've seen in terms of this judge's reaction to various aspects of this case so far, it seems like a done deal.
It does. It seems like a political show trial.
So the question is, has she done enough to give the defense justification for calling a mistrial, or for, at the very least, an appeal?
Well, a lot of people are talking about that they're, looking at other past cases, it absolutely could, they would deserve to have a mistrial in this case. But in the event that doesn't happen, it's automatic grounds for appeal to the High Court.
Right.
So if he doesn't get a decision in his favor, Assange, by the end of May with this hearing, it's a certainty that he will be granted an appeal to a higher court, which is the High Court, and then after that to, if necessary, to the Supreme Court. And I don't know if there's any higher authority than that, or the European Court of Human Rights, or would that not?
No. Well, not in this case.
Is Britain still opted into that?
Yes, yeah, absolutely. But I don't think that would. I don't know. We'd have to check that.
But the European Human Rights Convention is separate from the EU,
yes.
and Britain is a signatory to that.
Yes.
But basically, the prosecution's saying, send him to the U.S. We follow the letter of the law. We send him to the U.S. and he'll get a fair trial when he gets to the United States. Don't worry, says the prosecution.
Of course.
These are what the U.S. lawyers are telling us. So, but it's pretty clear that he's not going to get a fair trial in the United States, Mike. So a lot of people are hoping that it ends
here
on British soil, that Assange is acquitted and released as soon as possible. So it's a race against the clock, essentially.
Yeah.
His health is suffering. His mental faculties are suffering. He is absolutely vulnerable and exposed on many different levels in his indefinite detention. So how long can Julian Assange, the person, how long can he endure the sort of treatment he's getting by the British state right now? And if he goes to the U.S., again, same thing, Mike. Appeal to the high federal court, then to the Supreme Court.
Yeah.
That whole process from now, if that happened in the United States, we're talking about 5 years.
Yes.
So this is the question: 5 more years of his life.